Well, good afternoon, class. I have a real treat for you today. With us is Enrico Schaefer from Traverse City Legal. As you may guess from the name of his law firm, he's up north in the wintry wilderness up there. When we first asked the first day of class about about what different topics people were interested in hearing about, a number of you said you were interested in IP and trademarks and the international implications of that. And I immediately thought of Enrico. He and I have had the pleasure of working together on one case where our clients were international. The case is still pending. We're waiting for a judge to rule. And Enrico is my go-to if I had any questions about intellectual property, trademarks, the internet. I would call my good friend Enrico. So I'm hoping that you will enjoy hearing from him and learn as much from him as I have. And with that, I will turn you over to Mr. Enrico Schaefer. Enrico, why don't you start by just telling the class a little bit about yourself and your background and how you found yourself in the practice that you're currently in.
Yeah, so I am the founding attorney of Traverse Legal, which has offices in Traverse City, Michigan, where we started in northern Michigan, way up north, and then Austin, Texas, Detroit, and then a satellite office in LA. And we have always specialized in new and emerging technology company representation, which roughly translates into mostly intellectual property. And so we really started our practice to be have a global reach, and we really established our reputation on these niche issues of IP for tech companies and new and emerging technology. And that's how we got rolling in it. We started in 2004, and now it's 2019, and 35% of our clients are from overseas. We manage over 1,000 trademarks globally. We've got litigation pending currently in Australia, New Zealand, Vancouver, Brazil, and I'm sure I'm missing some other, as well as all over the United States on intellectual property issues.
Yeah, and in fact, this morning we were supposed to do this call, and you had to push it off a little bit because you were talking to Australia.
Yeah, so Australia is literally the other side of the time zone. And so those calls tend to be 8 in the morning or 8 at night, because
At night.
that's when we're going to switch up either morning or night between them. But yeah, 24/7. If you plan on doing anything in the international space, just plan on being available 24/7, because the time zones become this kind of second language, where you're constantly trying to determine where everyone is so you can set up a meeting where, at least it's between the hours of, 7 a.m. and midnight.
I hear you. I've done work in Japan and in Singapore, and I feel like I remember vividly setting my alarm clock for the middle of the night so that I could talk to my client at 2 a.m. because it was convenient for them. So, absolutely. Well, tell us a little bit, if you will, about some of the international work that you do, whether it be business consulting or whether it be IP or trademark litigation. Just give us a little a feel for some of the cases or work that you've done internationally.
Sure. So clients contact us, 35% of our clients are overseas, and they contact us because of some expertise that we've got in a niche issue. So the case that you and I have is an Anti-Cyber Squatting Consumer Protection Act case. The ACPA is a U.S. federal statute which protects trademarks in domain names. So you can't register someone else's trademark in a domain name. It's called trademark infringement. It's also called cyber squatting. It's a violation of the Anti-Cyber Squatting Consumer Protection Act. So for international clients who are trying to protect their U.S. trademarks on domain names, they're very often coming to us for that expertise. So we do a lot of that. It might be that we have expertise in a niche technology such as unmanned aerial vehicles or blockchain or something that is software platforms. So if it turns out that someone's looking for a tech lawyer then they might very well do a Google search. Google says we're number one, organic search result. So they contact us because we've written an article about their exact issue. So currently we have cases that really span everything from, IP litigation in other countries where we're working with attorneys in Australia, New Zealand, Vancouver, et cetera, where we're managing the litigation cases, but they're handling the cases locally. In other instances, we're just simply working with international clients who, quite frankly, most companies want to access the US market. So it doesn't matter where the tech company is located, they need a US attorney to be able to protect their code, to be able to negotiate contracts, to be able to deal with litigation, which ends up happening in the US. So Moodle is an open source educational software platform, which many of your students probably have used somewhere in their educational life. We've represented Moodle for 15 years. They are I can't remember how many hundreds of millions of people use Moodle at any given moment. And so,
unfortunately, our class uses Canvas, which I believe is one of Moodle's major competitors.
Yes,
but,
it is.
We won't tell anyone.
Well, we'll forgive you guys for that one. So, but for them, they've got international trademarks that they've got to protect. Moodle needs to be protected internationally, so we handle all of that for them. They've got partners all over the world. We do all their partner contracts, integrator contracts, all their different relationships are governed by contract, and we'll manage all of that for Moodle globally. They've got all kinds of different issues related to their open source software, GNU license, right? And so we have expertise in open source licensing and all kinds of different licensing issues. So we're doing all of these. I think we have 15, 20 different projects open for Moodle right now across a variety of different things. Where really general counsel for them, we just happen to not be located under their roof. And we do that for a lot of different clients. You may know Baker Mayfield. He's the Cleveland quarterback, right? So we represent him on all his brand protection issues.
Oh, how interesting. And is that worldwide, or is that mostly in the US?
So it's mostly in the US, but it's like everything else because of the internet, almost everything is worldwide. So for your students, where is the territorial border of any issue? It almost doesn't exist. If you've got any sort of of U.S. presence, your chances are you're reaching out to international customers. Well, if they happen to be in Europe, then you've got the GDPR privacy framework out of the EU that you've got to comply with, or you've got to block
Is that the new framework that we all recently received updates to all of our programs and our emails saying to comply with the new European law?
Yes, that's exactly it. All the new cookies and all the new pop-ups that say, I agree. They redid all those. It wasn't really necessary because they can't simply get agreement from users. What the fascinating thing about what's happening on the data issues internationally is that in the US, the way the law is structured is users can agree to anything, and they do whenever they access a website or click I agree without reading it, right?
Right, they can click through, and it's a click-through agreement.
Yeah, exactly. In Europe, it's exactly the opposite. Europe has spent a decade forcing companies to redesign their entire software platforms. Google, Apple, Facebook, all of these companies completely redid their entire platforms in anticipation of the General Data Privacy Protection GDPR statute in the EU. And what that says is, no, your data belongs to you, and it's a human right. So
it doesn't matter. Your data is like a fundamental human right. How interesting.
Fundamental human right.
I think I agree with that, but it's certainly not the way they treat it in the US.
Not at all. And so what they do is they say it doesn't matter what, like there's only certain things that you can agree to, but no matter what, the obligation of the tech company is to protect your data, to know exactly where it is, any duplicate copies, anywhere that you've shared it with, that you better have express permission, and it's not a global permission. It's on a data by data field basis, which is why if you were to really dig into some of these notices by Facebook, et cetera, and say, I'm going to look into this, all their new privacy settings, like they go on forever because every line of data has to be agreed to. But even if you do agree, you can withdraw that agreement anytime. And then you can request a copy of all your data, and you could ask them to delete it, and they have to not only delete it, but make sure anyone that they've shared it with is completely deleted if it's personal information, which means it standing alone or in combination with any other data can identify you. So it's a lot of the data.
This seems like a huge burden on companies. How are U.S. companies that do business under that sort of a scheme, what are they doing to try and comply with that? Because that's an onerous burden on companies. I know I read somewhere that a major company recently failed in its duty and fined. I can't remember which company, but I believe it was a major tech company. You probably know.
Google got hit with a penny fine, or maybe it was 84 million, which is just a penny to Google, right? So as part of a GDPR violation. But what happened is all these platforms, they're spending years knowing that GDPR was coming and redesigning their software, which is what GDPR wants. Every software company in the world to completely rethink their software platform from the ground up based on the human right of data ownership, privacy, protection. So the big companies have done that. Now, whether or not they got to actually the GDPR compliance level remains to be seen. But you can imagine the medium and small companies, if they already have a platform, for them to go back and redesign around GDPR is almost impossible. So what we've seen is this kind of risk reduction approach, which is all the pop-ups that you see, which is not GDPR compliance at all, but makes it seem like maybe the company's trying and posting the rights that you have on their websites under the new terms of service, which make it seem like you have those rights, right? But these companies have no idea where your data lives or how to delete it all, et cetera. And so there are a lot of companies who've basically, especially in the news and media, who've turned off all IP addresses to the EU in order to make sure that no one from the EU reaches their platform. Therefore, they've reduced the risk of compliance, because if someone from the EU happens to be traveling in the US, they still have the rights. So, but they're trying to manage the risk. And the GDPR understands that this is going to take a long time for people to get their brain around. And they're not looking to force things down everyone's throat. They're just looking to change the dynamic of the internet from big data, where companies get all this valuable data about you and then can do basically whatever they want because you said they could.
Whatever they want with it.
Right? To this whole different approach. And in California has come up with its own GDPR that it has passed with an implementation date of next year. And so now the big companies, because everything is global, are now trying to push Congress to regulate data and privacy, which of course they don't want that, but they're already doing it in Europe. They already designed the system. It's already designed for the US too to be implemented. It's the same system everywhere. And they would much rather have one federal. It's a huge competitive
advantage for them.
And it's a market barrier, but they can't deal with 50 different states regulating data privacy. So they would much rather fall on the sword, go to Congress, get national legislation and an express indication from Congress that all state legislation is preempted, and then just simply comply with that. It's going to be probably something short of GDPR. So, that's the way the world is going. And with all the stuff going on with Facebook and some of the different the big hacks that have occurred on data and the big issues that we see out there on privacy, the Russian bots, et cetera, like all of a sudden people are not only paying attention to data privacy in the US, but maybe for the first time in history, they're going to take it seriously. Because keep in mind, in 1992, when I started into internet technology, everyone was freaking because, oh my God, this thing called the internet. Someone invented this thing called the internet, and it's going to be Big Brother.
I believe it was Al Gore.
Yes, Al Gore invented the internet, right? And then he's kind of tall, so he would be a very big brother. Well, it turned out that Big Brother ended up being 100 times taller than anyone could have even imagined in 92, 93, 94. And the issue wasn't, people were talking about privacy and all that stuff, but at the same time, they're trying to figure out where to shove their credit card into the computer, right? Yeah, it's privacy, but where do I fall and, where do I throw myself in front of a reality TV camera, right? So Americans have always talked a big privacy data game, But when it comes to actions, we could care less about data privacy. We really, the drone space, like, oh, that drone's invading my privacy. I tell everyone the same thing. It's invading your privacy. You want to shoot it down this year, but in 3 years, you're going to be like, where's the drone? I ordered my package 2 hours ago. Where's the drone? I don't see it. Where is it? Why is my package not delivered? So everything tends to flip around on the data privacy game as soon as the convenience of the technology starts to kick in.
Yeah, and as soon as you feel like the convenience outweighs whatever small amount of privacy you're giving up, Americans have always been eager to throw that privacy away in exchange for convenience and inexpensive goods delivered to their front door.
Yeah, you remember the smartphone with the camera when that first came out? People were freaking out because
My goodness,
they thought so that people might bring it in restrooms, right? And that was the big, oh my God, people are going to bring their camera in a restroom. Well, how long did that last before no one even thought about that?
No one's, I mean,
people
no one even
in
thinks
restrooms,
about that.
right? Exactly. So
yes, in the mirror of the funny thing about this, of course, Enrico, is you and I are showing our age, because for most of the students who are watching this video, most of them have probably don't remember a time without cameras on their cell phones, let alone smartphones.
Right.
So our age is showing, but yeah, I do remember that. Tell us a little bit, if you would, about some of the international statutory schemes like the UDRP, that someone who practices in this space needs to be familiar with.
Sure. So one of the fascinating things that came about with the internet was something called the Uniform Domain Name Dispute Resolution Policy, or UDRP, which is a binding arbitration agreement that everyone agrees to when they register a domain name. And it basically, one of the pieces of the registration says you warrant that you are not infringing anyone else's trademark when you register this domain name. Now, does anyone read that? No. Does anyone know
that?
No. Did anyone even know that they agreed to binding arbitration? Well, of course not. But at the end of the day, if someone is infringing your trademark, yes, you could sue in the federal court in the U.S., but also you can go to some of these international arbitration groups that have been authorized by the Internet Corporation for Assigned Names and Numbers, to say, I want that domain name from the registrant because they're infringing our trademark. They're trying to monetize our brand. And it doesn't matter where you're located in the world, you can access the UDRP and you can force a domain registrar such as GoDaddy or registry such as VeriSign to force that domain name under your control if you win your cyber squatting action under the UDRP. And so it's really, I always say, it's like the first law in the history of the world that's really global. And the reason I say that, not that there aren't other contracts that you might agree to arbitration in, there's nothing else like domain names that is truly global, where you've got millions and tens of millions of domain names and being registered from people in every country in the world, and a single uniform system that allows a forcible transfer of a domain name. This is the way the world is going. We just talked a little bit about how the big companies want a single national standard in the US enacted by Congress on data privacy. That's not what they really want. They really want a global standard that would potentially be governed by treaty, by which they can simply comply globally with a single standard. Now, is that ever going to occur? Not in my lifetime, and maybe not in your student's lifetime, but you could see how the argument that we can't comply with all these different laws and regulations, it affects the big companies, yes, and they end up being in the press more. But if you're a small startup, how do you muscle the money
Huge barrier to entry.
Yeah. And it's really challenging. Yeah. Everything is global. It's not international. Maybe it's galactic at this point, right? So it's just the nature of commerce today is global commerce.
Well, one thing I learned from you, an analogy that you told me, and maybe you pulled it out of a case, I don't know, but I'm going to assume that it's from you, that really helped me understand trademarks and regulating domain names, was you said to think of the domain name that you type in like the the name over a store, like the sign over the door.
Yes.
And there's a big difference between having a sign over your door that says Nike versus having a sign in the window that says we sell Nike shoes.
Yes.
One over your door in your domain name is infringing because you're making people think you're Nike. But the sign in the window that says Nike, like a separate page or several, that's a whole different ball game. I don't know if that was brilliant. If you came up with it, you should keep that. But I wonder if that system is sort of widely accepted globally, or if that's more the U.S.'s scheme. I guess on a fundamental level, I'm asking if there's something similar to the Anti-Cyber Squatting Act elsewhere, or if that's a U.S. thing.
So the UDRP is global, but that only gets you your domain name back. It doesn't get you any damages or anything like that.
Right.
In the U.S., we have the ACPA, the Anti-Cyber Squatting Consumer Protection Act. It is the strongest trademark protection statute in the world. Other jurisdictions have trademark laws that can be argued to protect domain names. Other countries have special statutes which give special protection to domain names as the sign above the door. But there is no stronger law than the U.S., which is why a lot of foreign companies want to bring those actions, those trademark infringement actions here in the U.S., because we have the strongest law. And the real challenge is that if you can't get jurisdiction over the Russians who have stolen your domain name, right, you're never going to get damages over them. Now, under the ACPA, since Al Gore invented the internet, and therefore the U.S. Department of Commerce actually turned it over to ICANN, the Internet Corporation for Assigned Names and Numbers, as a kind of a socialist thing, right? Like, here's the internet, we're giving it away to the world, and we're not charging for it, right? And so everything was free. It allowed the internet to grow at exponential rates beyond anything we've ever seen before. And we have the UDRP that allows us to govern that. But because you always might need to get your domain name back, if someone is cyber squatting you under that ACPA, you can always in the US bring an in rem action to secure the domain name, even if you can't get it through the UDRP. So the ACPA is broader in its protection than the UDRP. If you really need to secure a domain name, no matter where you are in the world, if you're not in the US, you can access the in rem provisions of the ACPA. US has jurisdiction over all domain names. In a way that no other country does, because Al Gore invented the internet.
Right. Well, I would love it if you would tell a story or two, take a moment to think about some of your either your most interesting case or most interesting legal issue that you've come across. And just, I always enjoy listening to you storytell. I think the students will too. So take a minute and think of what you're gonna tell us. But tell us a story of one of your cases.
Well, this is a great story that you might have some familiarity with, but it's a foreign, Latin American resort chain that's got their hotel names, and they've got trademarks, and they're billion-dollar company, and they've got their trademarks in Latin America, which are fairly useless because the system down there doesn't work very well. But their customers come primarily from the U.S. So that means they have U.S. presence, and they need to protect their trademarks in the U.S. So in this case, a travel agency registered 50 some odd variations of the hotel names, cut and paste all the content from the websites of the hotel, posted that on the domain names, and essentially counterfeited, pretended they were the resort, so that customers would think, oh, I'm at the resort website, I'm going to reserve here, right? Because a lot of times people are like, I don't really, why should I reserve a room through one of these travel sites? I'd rather go right to the resort. And so they didn't even bother changing.
They've actually gone to a travel agent.
Yeah, to a travel agent. And then the travel agency has literally over 1,000 different resort names, mostly in Latin America. And they're just a mass cyber squatter. But the Latin American companies don't understand US trademark law. And so even though they're billion-dollar companies, they don't understand that they have rights, that this is illegal. Now, yes, are they getting the reservations ultimately? Potentially. Are they losing some? For sure. But they're not protecting their brand. If Nike lets someone else pretend it's Nike, that's not a good thing, even if they happen to be selling Nike shoes, right? Because in the travel business is about quality, and that's about customer service. And so who's answering the phone? Well, how long does it take to respond to an email? The travel agency is doing it poorly. That's going to reflect on the resort if the customer thinks they're dealing with the resort.
Right.
So,
It shouldn't, but since the customer doesn't realize they're dealing with a middleman,
yep,
they show up at the hotel and they're annoyed that they had such a poor booking experience. They think it's the
exactly.
hotel's fault.
Yeah, or the booking didn't get processed properly. Where's my booking? I booked directly with you, and then you'd retrace it, and it's like that's not us, right? So, so you've got not only this one client, but you've got hundreds of resorts throughout the Caribbean and Mexico that are getting cyber squatted by this travel agency, which is making millions of dollars off of this scheme. And again, because these Latin American companies, their trademarks aren't well protected in Latin America, they fail to appreciate that they could come to the US and fully enforce those trademark rights and shut this kind of activity down. So,
You've done a number of those kinds of cases, right? You've going
yeah,
back, what, 5, 6, 7 years? You've
10
been doing
years. Yeah, 10 years on
10
doing
years.
kind of Latin American resort IP protection. So,
Mhm.
so that's great. Then you've got the other companies that are, for instance, you've got, Moodle, who's got all these partners. Well, partners are located all over the world. They don't understand trademarks, so they'll start registering domain names that include the word Moodle in it.
Moodle.
And then you got to go to them and say you can't do that, right? And so all
And it
this
was probably in their contract that they
that they
couldn't do
can.
that, but
But who reads that,
they don't,
right?
they're not thinking, they're not paying attention. Yeah.
Yeah, and the marketing department's not speaking to legal, and legal didn't do anything to educate along the way. So then you've got all this international licensing. So we represent a forensic software company that does forensics on drones, and they are able to pull all the data out of a drone for police investigations, for government work, or for private companies who need to figure out what happened with this drone that crashed. And this could be military drones, or it could be the consumer DJI drones that you see around. And so now they're doing international deals with like the biggest forensic tech companies in the world to integrate their software into that platform as a module. So now you're into IP licensing, right? So you're going to license the software. Potentially you're going to want a white label, but you're going to want your brand on there somewhere. So there's branding requirements. Then you've got GDPR, so that you've got to deal with those issues depending on, this big global company has got customers everywhere. So very quickly things can get very complicated as a result of the international nature of virtually any business.
Everything.
And that's where we really have expertise that most law firms don't. Most of the big firms say they do, but they really have no idea what they're doing because they're not living and breathing it every day.
Well, I know that I doubt there's anyone who's really explored the cutting edge of drone law more than you have. I know that you not only are getting the drones properly registered in the US, I know you're also one of these like thought leaders thinking about all the different implications and privacy implications, implications of property when they crash, if somebody shoots
Yep.
them down, if they're used in commerce to deliver goods. So if anyone ever has drone law issues and they need someone good, remember this man's name because he's very good and cutting edge on drone law. Enrico, what would you tell someone who's been listening to you, listening to this video, and says, yes, this is how I want to practice. This is the area of law I want to devote my career to. How do I get from me sitting here in law school to you? How do I take, what classes do I take? What do I need to be reading? What do I need to be listening to? What's your recommendation if someone wants to have a career in internet law and IP and trademarks. And if somebody basically wants to be you,
Yes.
how do we do that? I'm listening because I want to be you too.
Yeah, sure. So, certainly a part of it is to understand intellectual property by taking those classes in law school. And once you get through your first year, you could start taking, all the different IP, copyright, trademark, patent law classes. Patent is a super niche area. So if you want to be a patent attorney, you can go do that. That's a whole different animal. But on other IP issues, get those classes in. But what I would recommend is this, what clients are looking for beyond IP, because there's a lot of IP attorneys out there, is an attorney that actually understands their technology. So being a IP attorney who specializes in unmanned aerial vehicles, which roughly translates into autonomous, which can not only be drones, but automobiles. So we opened a Detroit office to service the autonomous vehicle market that's burgeoning in Detroit, with Ford bringing its entire autonomous group downtown Detroit, and all the tech companies that are going to pop up around that. It's the same technology in drones as it is in automobiles. So what other attorney in the state of Michigan has as much experience on autonomous technology as I do? I went back to school, 6 years ago, 7 years ago, to learn about all of the different controllers and the software and hardware components of autonomous. So I'm an IP lawyer who actually understands the tech background of the product. And it's about everything in the world is going niche on niche on niche, right? So IP is a niche, but new and emerging technology is a niche. Put those two together. Now go into autonomous, which is even nichier. The more niche you are, the less competition there is. So while there are tens of thousands of IP lawyers, there are only a relative few who do things that I do in IP, and it's, globally there might be 5 or 10 of us, and that certainly increases the odds of getting business clients
that you're going to get hired.
Yeah, exactly.
Yep. So what do you think? If fresh out of law school, is it big firm, small firm, boutique that only does IP? What's your recommendation? What would a career path be that you think would be accessible to most people?
Well, so obviously the big firms have resources and mega clients, but I will tell you that that would be your probably your last choice if I were you, because you're going to get sucked into that, and you might wake up someday and be 65 and be still doing the big firm thing, which is a brutal lifestyle. It's no fun. It's humorless, and it's just they're just you're just a billable hour to them. So try to avoid that.
None of them have a picture of Prince on the wall of their serious offices, and yeah.
Exactly.
None of them have. You can't have that. You're not allowed to have anything fun like that in your office.
Not at all. So, if you got to do it, then get in and get out. Don't get in debt, and get in and get out, get your experience. But the medium and small firms are where it was the future of law. You don't need to work for a big firm to be the best in the world. In fact, we go up against the biggest firms in the world all the time. They're complete idiots. They don't have no idea what they're doing. There's no strategy. They don't understand the technology. It's like they're little robots that just bill hours, and that's all they ever think about, right? Well, the beautiful job about this business is thinking like a business person, and then being able to provide legal services on a return on investment point of view, thinking like the owner of the business. And that's what clients want. That's the future of law. That's where it's all going. And these big firms, they really can't compete today with the smaller firms, and it's only going to get worse for them moving forward. Like every other industry, small is the new big.
Small is the new big. Well, with that brilliant piece of advice, I will thank you so much for giving us your time. Indeed, sir. And this has just been wonderful. I hope the students have enjoyed it as much as I have. And I think probably you have a class full now of people who are fascinated by internet law and the new and emerging technologies that brings with us. So thank you so much. And I will talk to you soon because we've got a case together.
We do. Thank you. And good luck to your class. I appreciate you having me on today.
Thanks very much.